basically prohibit, discrimination on employment matters and even generally on health matters, as we have seen in the previous section. And then Section 25 of the Act states that the federal law addressing genetic discrimination in health insurance and employment is incomplete in both the scope and depth of its protections. And then, moreover, while states have enacted some type of genetic non-discrimination law, these laws usually vary widely with respect to the approach, application, and level of protection. So Congress came in once again and it went ahead to collect, some substantive evidence that, the public and the medical community of America find existing to be confusing and inadequate to protect them from discrimination. So here we are seeing a scenario where legislature could be there, and this legislature is tasked with addressing genetic discrimination, maybe in health insurance and employment. But this particular legislature is incomplete. And by virtue of it being complete, it becomes inadequate and it fails to protect the community from discrimination on the basis of genetic information. So the federal legislation establishing a national and uniform basic standard is necessary. That way the public is fully protected from discrimination, and their concerns about the potential cases of discrimination that would come on them have actually been taken care of before they actually come. And this allows the individuals to be able to take advantage of genetic testing, to be able to take advantage of technologies, research, and new therapies. So now I'm going to specifically focus on, genetic non-discrimination in health insurance, and I'll make reference to Section 101 under Title 1, which is amendments to the Employee Retirement Income Security Act of 1974. And it basically states that, no group-based discrimination on basis of genetic information. And in general, there's the issue of, a group health plan and a health insurance issuer offering group health insurance coverage in connection with a group that has come together to have a group health plan. And it may not adjust, the premium or contribution amounts for the group covered under such plan on the basis of, genetic information. And the rule of construction is that there is the limit when it comes to the ability of a health insurance issuer offering health insurance coverage when it comes to group health plans, when it comes to increasing the premium for an employer based on the manifestation of a disease or disorder of an individual who is enrolled in the plan. So basically, in as much as this health insurance issuer has certain rights, there is a limitation to that, because I believe when such a right or when such an obligation has been made absolute, then there's a possibility that this health insurance issuer will obviously go ahead and abuse it. So in such a case, when a disease or disorder has manifested in someone, it cannot be used as genetic information about other group members and to further increase the premium for the employer. So basically what this particular section is saying is that in the case where someone within a group is found to be sick, you cannot use someone's sickness so as to provide gain in one way or another for the other group members in question. I'll make reference to now the issue of remedies and enforcement, which basically falls under Section 2722B of the Public Health Service Act, which was amended by adding at the end the following. So generally, the provisions of this paragraph will apply with respect, to an action under this subsection by the secretary. And this is basically saying that there will be an authority that will be put in place so as to ensure that genetic information, or rather, you don't really receive discrimination based on genetic information. And this is a good step, because I believe the moment an authority is there, then they will be able to address issues relating to violations of genetic non-discrimination provisions, the issue of health insurance coverage, the issue of cases where one individual has a manifestation of a disease, and then how the other members want to benefit from that, maybe by the premium increasing, etc. So this authority specifically deals with such issues. And then now on the employment, now that was now the health insurance side. So this is the prohibiting employment discrimination on the basis of genetic information. I'll refer to section 202. And it basically says that it is unlawful for an employer to, fail or refuse to hire or discharge any employee, or otherwise to go ahead and discriminate against any employee with respect to, compensation, just because of genetic information regarding that particular employee, or to go ahead and, limit or classify the employees of the employer in any way that will sort of make this employee deprived of certain employment opportunities that will otherwise be given to him or her, or otherwise, adversely affect the status of the employee as an employee, sorry, because of genetic information. So here we are seeing a scenario where an employee has been protected by this particular act, the GINA Act of 2008. And we are seeing a scenario where, an employer probably wants to go ahead and discriminate against their employee on the basis of genetic information. And this particular act basically criminalizes and says that it is unlawful for an employer to actually, do exactly that. And then there's the issue of the employment agency practices. So this one is similar to the one that I've just made reference to. The only difference is that here it is employer practices, and then here we have the issue of the agency practices. So the content is basically the same, whereby again it is unlawful for an employment agency to go ahead and refuse employment to someone, basically because they have certain genetic information characteristics, or to maybe go ahead and limit or classify individuals on the basis of their genetic information characteristics. And the moment you do this, you are basically exposing this particular employee and depriving them of certain employment opportunities. So all this has been criminalized, and all this has been declared unlawful under GINA of 2008. And then we also have a labor organization practice. Again, the content is the same. The only difference here is we're now changing it from an employer, the employment agency, sorry, and then we have a labor organization. And once again, it says that, it is unlawful to expel from the membership of a labor organization any member because of their genetic information with respect to that particular member, or to go ahead and classify the members of the organization and causing them to be deprived of certain opportunities that other members are enjoying, purely because this particular member has, certain genetic information characteristics, or causing an employer to be discriminated in violation of their title purely on the basis of the genetic information. So once again, we're seeing a scenario where this same act, the GINA of 2008, has gone ahead to criminalize those situations where we have labor organizations going ahead to discriminate against their members purely on the basis of genetic information. And then we have section 205, which relates to the training programs. And once again, the content is the same. Again, this GINA of 2008 goes ahead to declare how unlawful it is for a training program to discriminate against any individual who has maybe come to join the program because of genetic information with respect to that particular individual, or to classify certain participants or applicants purely on the basis of their genetic information. And then also the issue of causing discrimination against the same applicant purely on the basis of genetic information. So once again, similar to the labor organization, similar to the employment agencies and the employer practices, we are seeing a scenario where GINA has gone ahead to criminalize and declare unlawful employment practices where the training programs are openly discriminating the applicants, the apprentices, etc. And then now, finally, section 208, sorry, which has the disparity impact. And here we are seeing, so the area of focus is this particular provision, which says that, on the date that is 6 years after the date of enactment of this GINA Act, there shall be established a commission known as the Genetic Non-Discriminating Study Commission, referred to in this section as commission, whose role is basically to review the developing science of genetics and to make recommendations to Congress regarding whether to provide a disparate impact cause of action under this act. So as I finalize, if there's one thing that really stood out for me when I was looking at this GINA of 2008 is the fact that it really brought out the key topics that are affecting individuals. For example, when it comes to health. So to me, it felt like bringing it now to the Kenyan context. It's as if the Health Act and then the Employment Act and then probably the UN Charter coming in all under one particular act to address very, very key issues when it comes to the issue of genetic information. And the final thing that also stood out for me was how, they will go ahead and basically, like this, the provisions of this act would outrightly discriminate scenarios where not discriminate but criminalize scenarios where employers, employees, or people when it comes to health issues are being discriminated and declare those particular acts as criminal or declare them to be unlawful. So that is basically what I found on the Genetic Information Non-Discrimination Act of 2008.
Thank you very much, Chelsea. Are you coming after my job? Because I will give you a very good fight for it. That was very good, very well done, very well presented. Are there any questions to the presentation? Any questions that were raised that came to your mind as Chelsea was preparing or presenting rather? Any questions? All right. All I can do really is to just add a few pointers. Okay. Yes. Whose hand is up? Let me just have a look. Yes, Donald, go ahead. Donald, can you hear me?
So yes, I can hear you. So I was asking the last section 208. Does it mimic something of a sunset, something like a sunset clause or something like that?
Okay. Do you want to answer that, Chelsea? Go ahead.
Yes, I do. Yes, it does. I believe when you say sunset, you're referring to it being like a closing remark or something of the sort. If not, maybe you could correct me. But yes, it does because it's actually the last section in that particular act that addresses, the issue of discrimination. And I think for it to even become more sunset, like more sunsety, is where now it talks about now the act has been enacted and then 6 years after there is the establishment of that commission, the Genetic Non-Discrimination Study Commission. So yes, to answer your question, it could be referred to as, a sunset clause or section.
Okay, thank you. Good question. Well answered. Any other questions before we proceed? Okay. So let me just go through just some general additions. So obviously we're talking about the GINA law in America. It's a federal law. Just note the difference between a federal law and a state law in the United States. It's kind of like the difference between a national law in Kenya and a county law, although obviously the scale is different. It prohibits discrimination in health insurance coverage and employment and where that discrimination is based on genetic information. Obviously, it came into play because at a certain point before 2008, people were being discriminated against. Either they already had the job and they were being constructively dismissed because of genetic information, or at the point of recruitment or applying for jobs, they were being ignored or discarded on the basis of submission of application documents, which included genetic information reports or testing reports. So basically, this law, this federal law, provides a baseline level of protection. Obviously, we know that with any law, at least in the Commonwealth, what is provided in the Act is a bare minimum. You can provide more if you want, but you cannot go below the bare minimum that is provided by the Act. So in the same way, this Act provides a baseline protection against genetic discrimination. And then what happens in the states with the federal laws is that each state is given the freedom to build upon those laws. So they can provide even stronger protections than the federal law, but they're not allowed to provide less protections than the federal law, which is why it's a side note why it was important, for example, that the Roe v. Wade case be overturned, so that individual states now can legislate as much as they want without having a baseline protection that is afforded to them by the Roe v. Wade decision in the 70s. Okay, so GINA prohibits health insurers or health plan administrators from requesting, number one, or requiring genetic information of an individual or that individual's family members, or using it to make decisions regarding coverage, that is insurance coverage, or pre-existing conditions, or even to ask if a genetic test has ever been conducted. Because you may have done one maybe as part of your marriage counseling, for example, and then you have an existing genetic information test, and then when you're applying for a job, some places would ask you, have you ever taken a genetic test? And then they use their contacts to find that information and then use that to discriminate against you in any of the areas that we've already mentioned. Now, we have now an example of how the GINA law has been, has been improved upon, shall we say, at state level, at individual state level, is the California GINA Act. I had given someone that to do, but I suspect she's not here today. Was it you, Beryl? Or Arike, yes?
Yes, you had given me to the...
Oh. Okay, good. Do you want to go ahead and present briefly on the California GINA Act?
Yes, I will. Unfortunately, I will not be making a presentation as I'm on my phone. My laptop went off. So I'm just going to do a verbal presentation. And so as Chelsea has has presented, the GINA Act is the federal act. And so within now the states themselves, some of the states have their own acts. So one of them is California, and California has what is known as the CAL Act. Basically the CAL GINA Act, which is basically the GINA Act, but the Californian version of it. And so from the preamble of the Act, it follows just what the GINA said, but in the context of what California as a state needs. So the Act says that the early science of genetics became the basis of state laws that provided for sterilization of persons having presumed genetic effects. Chelsea has already talked about that from the federal law, particularly sickle cell, which was presumed to occur mostly in African American persons, and so it led to a lot of panic, and which led to discrimination, laws that particularly discriminated against African American persons, and mandated genetic screening of all African Americans for sickle cell in the 1970s. And so the state of California was cognizant of that. And then the state also talks about the case about the genetic screening at Lawrence Berkeley Laboratory, which led to the case of Norman versus Lawrence Berkeley Laboratory in 1998. And so they say that the state of California has a compelling public interest to realize medical promise of genomics, and it has a compelling public interest to relieve the fear of discrimination in prohibiting the actual practice. The state of California recognizes that the United States federal government through Congress has enacted the Federal Genetic Information and Non-Discrimination Act of 2008. However, it says explicitly that those range of protections is incomplete for Californians, which preempted California to make its own law. And so the CalGINA essentially accomplishes its objective of providing further protection for Californians by amending two key Californian laws. That is the Fair Employment and Housing Act, and then the UNRUH Civil Rights Act. I don't know if that stands for something. I kept looking for what it stands for, but I fortunately could not get that. And then it also amended some codes, which is the Business and Professions Code, the Educations Code, the Election Codes, the Government Code, the Penal Code, the Revenue and Taxation Code, and the Welfare and Institutions Code. And so basically the definition is the same in both the CalGINA and the GINA itself. And it includes what we talked about in class yesterday, an individual genetic test of an individual family members and the manifestation of a disease or disorder, but it does not include information about individual sex or age. So unlike the GINA, it protects, it extends non-discrimination protection to areas of employment and health insurance, and it prohibits acquisition of genetic information and extends non-discrimination to additional areas like, for example, receiving of medical emergency and receiving of emergency and medical service care, recording and enforcement of restrictive covenants affecting the interest in real property. And we had already talked about this in property law, so I'm assuming that people remember what that is. It also protects the receipt of services, access to facilities, accommodations, privileges, and all business establishments of every kind whatsoever. It protects against the distribution, it protects non-discrimination. It provides for non-discrimination against distribution of alcoholic and club licenses. And then another thing, seeking, obtaining, and holding employment. Another thing that is different, particularly in terms of employment in the CalGINA that is not necessarily in the GINA, is that CalGINA provides for unlimited damages where the employer has been found to have violated non-discrimination law in regards to genetic information, whereas the GINA does not provide for this. And then CalGINA also makes changes in other statutes. For example, Section 3228 of the Education Code. It also makes changes in the Government Code. It makes changes in the Election Code and in the Revenue and Tax Code. So basically, what I found the difference to be between CalGINA and the GINA itself was that CalGINA made itself particular to the state laws in California, so that in places where the GINA might not necessarily have had the opportunity to reach, CalGINA tried to broaden the protections that it offers the people of California in terms of genetic information and discrimination. I will post my write-up in class in the classroom after the class. Thank you.
Okay, thank you very much. Thank you very much, Enrique, for that. I'll just also, just as I did with Chelsea's presentation, I'll just add a little bit more to it. So it's actually Enrique has gone into great detail about the CalGINA Act, which is commendable. So all I have to add is that it came into force in January 2012. So some 4 years after the GINA, the federal law, came into force. And basically it amends the existing anti-discrimination laws and basically expanded them. So if you look at the GINA Act was concerned mostly with insurance and employment. Now, what the CalGINA Act is, it extended it, so it added even more protections against discrimination in the areas of housing, mortgage lending, okay, education and public accommodations. So that now you could not be refused, especially in these countries where they have a welfare system, as they do to some level in the United States. So you could have a child being refused to go to a certain school because of a genetic test, or people being refused public housing because of a genetic test, or people being refused mortgages so they can be able to buy houses because of a genetic test, or their rates or their interest rates are hiked because of what the lenders perceive as a higher risk. Because let's say, for example, you have a genetic test that says you are predisposed to a certain illness, which means you have a life expectancy of, let's say, 40 or 45, which means that if the lender asks for your genetic test and they find the genetic predisposition, then in their minds they're thinking, usually we lend to people knowing they'll be paying back up and way past their retirement age when they're 65, 70, etc. But if this genetic test shows that you have a predisposition to a genetic illness, that means you will probably be dead by 45, it means they won't get their money back, okay? Or they won't get a substantial amount of money back. So either A, they reduce the amount you can borrow, or B, they increase the repayment amount. So instead of you paying back 50K a month, you're paying back 250K a month, because they're worried that you might die and not be able to pay off that amount. Or the third thing is they refuse you the loan altogether. And then therefore you are denied from a fair opportunity at wealth creation, at being able to purchase your first house, for you and your family, and so on and so forth. So those are very real concerns that come from discrimination based on genetic testing, okay? Especially when it comes to finding out, or when it comes to issues or rather genetic predispositions that mean that you might be ill, you might not have a long life expectancy, you might not have cognitive function, like it might have your mental health state will be affected, your cognitive state will be affected, so that you are not even able to recognize yourself or recognize anyone else, or recognize that you have bills to pay, or mortgages to repay back, or loans to repay back, and so on and so forth. Okay, so thank you very much. So we'll go to Canada and see how they deal with issues of genetic testing. Can you all hear me?
Yes.
Okay, thanks. So let's move on to Canada and see how they deal with this issue of genetic testing and anti-discrimination. So the Canadian Life and Health Insurance Association has issued a position statement on the use of genetic information. And basically that statement says that insurers will not require an applicant to undergo genetic testing, but if testing has been conducted and the information is available, insurers will request access and expect to see test results. Okay, and you will know that this is the opposite of what is permitted in the US in the context of health insurance, because in the US, as I've mentioned before, the insurers are not even allowed to ask if you've had a genetic test before. But the Canadian position is basically to say that we will not require it, but if you have had it done, a genetic test done for other reasons, and that information is available, you will be expected to provide it. So there's a slight erosion of the protection that is provided in the United States when it comes to Canada. And also note that the person who's giving this position statement is the insurance association, the Health Insurance Association. And what one can glean from this? And this is not a legal position. It's a statement by the Health Insurance Association. what does that say to you, or what bells does it ring in your mind when you see that, in your understanding of the world, how it works? Anyone who'd care to? Yes, Arike?
I think this person is definitely working in the interest of the health insurance industry rather than the interest of the people, and that's why they are preparing this loop. They are creating this loophole that does not exist in the US. I'd just like to mention that it echoed something that you were talking about experts and their leanings, and how it creates it kind of influences what information they're going to give you. Because so for example, an expert in human rights law, who we can maybe presume is the one who worked on the US law with their legislature, would not have created this and did not create this. But then this person who is a form of expert in the health insurance industry, maybe an expert just for the fact that maybe they've worked there for a long time, or they have a lot of knowledge here, then whatever they give you, the information that they give you is more inclined to the interest which at the end of the day they aim to serve.
Okay, that's a very good point. So number one that we can glean from this statement is that it is clearly leaning towards the insurer's best interest as opposed to the individual, citizens' best interests. Okay, because they still want to have some semblance of control in respect of what premiums they give, in respect of mitigating the risk of the insurers. Because you're talking about the insurers association, so you can presume that this is the position of insurers, with health insurers within Canada. Another thing that tends to happen when you see insurers give statements like this or a group or associations of insurers give statements like this, is that they're trying to preempt perhaps a law that is in the works, that is in Parliament. So basically what they're trying to do is tell parliamentarians and the citizens at large within that jurisdiction is that we've seen the problem and we are self-regulating. Okay, remember we talked about self-regulation when it comes to pharmaceutical companies or banks or people in the health sector, because the purpose of self-regulation is to show the voters and the government that we are taking matters into our own hands, so we don't need a law. We don't need a law, because once we're self-regulating, that means there's no problem and there's no issues at hand. So it's kind of trying to preempt a bill passing through Parliament and then being assented into law that might actually work against them. Because once you go through the debates and all the holes are picked apart and all the loopholes are figured out and sealed, then it means that the insurers will have less leeway and less room to operate the way they want. That's why insurance lobbies are a huge, huge deal, not just in Kenya, but also around the world, especially in the established Western democracies like the UK, Western Europe, and the United States, because they're the ones who actually make the most out of these they're the ones who benefit the most out of insurance deals, because the average person who pays for life insurance will probably not use it that much, but will have given the insurance company a lot of money, which they might not be able to recoup. Yes, Ibrahim, go ahead.
Yes, Mwalimu. I think as much as we are saying that the insurance industry of Canada are self-regulating, I think also there is a loophole somewhere in terms of the kind of queries they can put to the database that's contained in the information. I think there is need to regulate the kind of queries they can make and even the replies, because it should not be open. Because some of the replies or queries they can post to the database can be very sensitive. So probably there is need to regulate. As much as they are not directly accessing the information, they may be going through a database provider, but I think there is need to regulate on the kind of queries they can post to the system. And also if some of the replies are very sensitive, then that can be withheld from them. I think there is that kind of loophole I'm seeing there.
Yeah, Absolutely. And so without a robust legislation that actually has had, public participation, input from all the stakeholders, people who are affected because they were, they were forced to pay a higher premium because of a genetic test, or they were forced to provide a genetic test just for basic housing insurance or car insurance or things like that. Not just health, because it does happen in certain countries where they're told for any policy that you want to take, even for school fees or whatever, we need a genetic test. And then if they don't provide a genetic test, then the automatic result is your premium goes high, and there's no law regulating what the insurers can do. So and so there's been a trend, and this is not news, there's been a trend where whenever the insurance sector feels under threat, or they feel like a law is about to be passed that will greatly impact upon them and their income generation, they put out policy statements like this to try and do a PR camp. It's mostly for PR to calm people's fears about what they're about to do and buy themselves time. So that, because obviously, the average law, takes quite a few years to come into being, give or take, depending on what the issue is at hand. And so they'll try to put out statements like this to try and slow down or stop altogether any impending bills that might negatively impact on the operations and the income generation of the insurance sector as a whole. So there's just one thing I wanted you to be aware of. So next time when you're going through your reading, you are also aware of other factors at play when it comes to this issue of insurance and genetic discrimination, or an anti-discrimination on the basis of genetic information. So now let's leave Canada for a second. We go to the United Kingdom. And then similarly to Canada, the Association of British Insurers, in concert with the government, which is also not news, because a lot of times the insurance lobby will work hand in hand with the government, and the insurance will promise the government something in terms of maybe adding to their treasury in exchange for less stringent legislation or no legislation altogether. That you can read on your own time. There's even movies based on that, or which have that as part of the plot or the theme. So the Association of British Insurers and the government in 2017 extended a moratorium to 2017, and that was, I think, was a 5-year moratorium. So what happened was that there was a complaint about British insurers basically taking advantage of their position, charging exorbitant premium rates and all that kind of stuff, and then also asking for genetic information for the most mundane of policies, insurance policies. So they agreed on a voluntary moratorium. Okay, that's the insurers and the government, where which extended to 2017 and then again extended 2019 on the use of predictive genetic tests for life insurance policies. So this is specifically to life insurance, okay, under £500,000, or critical illness policies under £300,000. So basically they said that, but basically what that means is the insurers and the government, because of noise that had been made about their practices, which were basically said to be discriminatory, they agreed with the government that it's a voluntary moratorium. So it means that they can withdraw the moratorium anytime they feel like, if they feel it's not serving their purpose. But because they've agreed with government, it means they have to actually agree with government to withdraw the moratorium and let the public know in advance, so they plan accordingly, or take the necessary legal action to stop them. So they agreed that where an insurance policy, a life insurance policy, is under £500,000 in value, or where a critical illness policy is under £300,000 in value, then they will not ask the policyholder to provide a genetic test, a predictive genetic test. And obviously, as we've discussed, a predictive genetic test is one that predicts the likelihood of you getting any one of a myriad of genetic illnesses, from Huntington's to Alzheimer's to diabetes, to what you call glaucoma, to any of those things, the ones that we know of and many that we don't. And then obviously, conversely, it means that if your life insurance is worth over £500,000 or your critical illness insurance cover is worth over £300,000, then the insurance can only use genetic test results if the disease if the disease has been approved, and if the policy, or rather the the product, as in the insurance product, has been approved. Okay, and currently insurers may only use genetic test results for Huntington's disease when selling life insurance. So that was the kind of informal voluntary agreement that was agreed between the government and the Association of British Insurers, basically for the reason that we've mentioned before, is to stop government basically coming in and putting in a regulation or a directive, or the MPs, the legislators, going to Parliament and putting in a law that would actually stop them from asking for genetic tests altogether. So they're saying, okay, fine, we'll then have a threshold above which we can ask for genetic information, below which we are not allowed to ask for genetic information. And then even asking for genetic information is specifically for life insurance and critical illness policies. Okay, and then and specifically when it's life insurance, is for Huntington's disease. Okay, let me just go to another country, and then I'll pause. Excuse me. I'll pause so that people can ask questions, and I can also have a sip of water. We go to Germany, and when it comes to insurance and genetic information, in 2009. The federal parliament in Germany passed the Human Genetic Examination Act, which prohibited insurers from demanding genetic examinations or analyses, or demanding the results from such examinations, except in limited circumstances. So that act, if you compare it with the UK, this voluntary moratorium, as they're calling it, is clearly more restrictive to the insurers than this voluntary moratorium, because you see there's a cap placed there, and they've decided to limit it to certain illnesses, but obviously it's a voluntary moratorium, which means that it can be removed at any one time. So in contrast, what the German Human Genetic Examination Act did was to allow the request of genetic test results only for life insurance, occupational disability insurance, and pension insurance. Only those three would a request for genetic testing be allowed. And even in those three cases, you'd only be allowed to ask for that testing where the policy pays out more than 300,000 euros, okay, or an annuity of more than 30,000 euros annually. So what an annuity means is basically, you have these insurance covers that say if you don't claim anything for a certain period, you'll get some sort of like what's the word for it? Someone help me. It's like a windfall. It's like a thank you for not claiming on your life insurance. We have made so much money from you, but we'll give you a fraction of the money that we've made from you. And in this case, the annuity would be 30,000 euros per year, which is not small change. But if you're getting back 30,000 a year, imagine how much the insurance company is making from you. Okay, so that's some food for thought. So basically, they put those restrictions. An insurance company can only ask for genetic tests for those three types of insurances, that is life, occupational disability, and pension. And even then, they can only ask where the policy either pays out more than 300,000 euros globally, as in total, or the insurance policy gives the policyholder an annuity that is basically like a cashback, like not free. I was going to say free, but it's not free, but a cashback of 30,000 euros annually for policyholders who have not used or claimed their money back from the insurance. Okay. Another thing, we're going through all this as comparisons to see how different jurisdictions are dealing with this genetic information situation, and specifically with insurance discrimination. The Council of Europe issued a consultation document on predictivity, genetic testing, and insurance in 2012, and the aim of this consultation was to get feedback from different stakeholders on a what would be an appropriate legislative framework to protect genetic information, and also discuss whether to legislate in respect of genetic information, whether we're doing it statewide or within specific jurisdictions, or are we doing it across the European space? Because obviously the Council of Europe would fall under the European Union. And basically this has remained unresolved on whether to have one sweeping legislative framework that covers the whole of Europe. That has still remains unresolved to date, from to the best of my knowledge and my research. So that is basically just a small kind of comparative look at the different jurisdictions and how they're dealing with the issue of insurance and genetic information. Do you have any questions up till there before I move on? Or view comments? What are you seeing? What patterns are you observing? And what do you think so far? We can have one or two comments, or perhaps maybe I continue so as you're formulating your questions. Yes, Chelsea, go ahead.
Mine isn't a question per se, it's more of a comment. And I was just trying to sort of, juxtapose GINA with maybe the Council of Europe or the UK or Canada, and then CalGINA Act. And I think one thing that cuts across is that all of them seem to put so much emphasis on the protection of, genetic information. Like, I think that is the underlying issue that cuts across all of them. And specifically looking at GINA now seems to go into details when it comes to, the issue of discrimination. But then I was looking at the other one, I think not California, the Canada one. And even this one, in a way, it's sort of, when it says that the insurers will not really require an applicant to undergo genetic testing. But then if testing has been conducted and the information is available, insurers will, request access and expect to see test results and whatnot. So one thing that I think cuts across is, the protection of the genetic information. And it begs me to ask an quote unquote indirect question. Why is it that there is such, heavy protection when it comes to genetic information? And I remember you taking us through the issue of patents, intellectual property. And I was asking myself, okay, yes, when it comes to patents and intellectual property and protection of the same, there isn't really as much protection as you see with the issue of, genetic information, whereby we even have, international legislation putting so much emphasis on, protection of genetic information. So I wonder, what is this gold mine that, this genetic information is all about? That's just what I wanted to comment regarding what you have just taught us.
Okay. That's actually a fair point, and actually it's interesting that you've put the genetic information side by side with patenting, because they do kind of overlap, and we'll see that with the last couple of cases that we'll talk about. But I guess then that's why it's even more important. Not I guess that's why it is even more important that genetic information is protected, so that by the time genetic information has has parlayed itself into, let's say, what do you call it, into a vaccine or a drug or some sort of novel new idea that is patentable, even the patenting process should take cognizance of the process that has been taken to produce that patent, so that now it takes that into account the status of genetic information, and then also perhaps even creates a new system within the patenting system to address those issues, as we will see in the Greenberg case. Anyone else? Yes, Arike?
So something that I see, especially in the insurance sector, as it relates to genetic information, something that I'm seeing cut across the board is exemptions. So while the law is interested in protecting the genetic information of its people, it's still also cognizant of the fact that there still has to be some exceptions existing if the insurance company is going to function as an if the insurance industry is going to function as an industry. So, like in Germany, in Germany, we've discussed that where you did not claim, then you get some money, then a certain amount of money, then in that instance, the insurance company is allowed to ask, or if the life insurance is of a certain amount. We've discussed also in Britain, in England. So I'm seeing a lot of exceptions that exist even, and the council and Canada, where the insurance industry created their own exception. So I'm seeing a lot of exceptions that exist, so that it's not blanketly that insurance companies cannot ask for genetic information. There's some instances for genetic testing. There's some instances where they can ask for it. And then secondly, I noticed the Canadian Insurance Association, this I don't know what to call it, the one that they gave the statement where they talk about if the testing has been conducted and the information is available. So I'm wondering about this availability of information, because if the government wanted to completely put them out, the government, when enacting the law, can just make provisions to say that that the people who have this genetic information after the testing are not allowed to give them to anybody, any other person, without the authority of the person who owns the genetic information. In this way, if the law is prohibiting it, then I don't think it will be available. And so, while it is an exception, I think it's an exception that it would be quite easy for legislators to circumvent if they wanted to. And then thirdly, when I was thinking about that, I tried to see if in Kenya, like take this and put it in Kenya and see if the closest thing we have to genetic information would protect Kenyans against this. And I think at the moment, it's the Data Protection Act that we have, the closest thing to the protection of genetic information that we have. And I think it's very insufficient as an act. Even when looking at GINA, when looking at CalGINA as an act, it's very insufficient, because it explicitly says that where another law, when another law gives the right to share the data, then the data can be shared, which is very strange, because then if it is the law that is protecting people, why then leave it open to other laws to come and take this, for other laws to come and be above it? It seems very insufficient to me, particularly in section 51(2). The processing of personal data is exempt from the provisions of this act if disclosure is required by or under any other written law or by an order of the court. So the other things, it's national security and public interest. I just don't understand why they would let any other law come and circumvent this law, where like this law is meant to be the law that is protecting the genetic information of Kenyans at the moment.
I agree with that. Let me interject. Sorry, keep your train of thought. I know I've interjected, but something important actually that I went on a seminar a few years ago regarding, IT and the GDPR before this act, the Data Protection Bill became the act that we now know in 2019. And one of the things that the drafters were saying, and there were some people who took part in the drafting and some people who were stakeholders, etc., who were talking in this conference. And one thing that came out was the Data Protection Act that we have in Kenya is literally verbatim, word for word almost, the GDPR, the European General Data Protection Regulations. They literally, our laws, as with many laws, you can list them out, was actually lifted from the GDPR, the European GDPR. But one important thing that they did was put in that section 51 that you're talking about, which is basically to exempt government and the court and certain state actors from the provisions of GDPR, which basically means then we are not protected, because all that needs to happen is that government gets involved, or the police get involved and the court gives an order, and suddenly you do not have any data protection rights. So that was one major key change that happened with our act that does not exist in the GDPR, because the GDPR, because it's a European-wide piece of legislation, regulation, which is a legislation as well, actually protects individuals not only from their own government, but from other governments within the European space, the European Union space, which we do not have. Again, my personal opinion was this bill was passed very quickly to enable the Huduma Act bill go through. And obviously the Huduma bill, if it becomes an act, does not work if Section 51 does not exist. You see what I mean? So all our information, basically, our government as it stands does not have the same burden on it to protect and deal with our information responsibly by virtue of Section 51 of the Data Protection Act. But that's something that I thought I should share with you, so you're aware, even as you're reading the Data Protection Act, because it can form part of a discussion, part of your CAT, part of your exam. So it's something you need to be very aware of and understand the implications and the consequences of it. Yes, Arike, go ahead. Sorry, I interrupted you.
It's okay, but basically that was going to be my last point. I was going to
I'm sorry.
But it's fine. That the court was saying we don't really have enough regulations, enough laws to protect the genetic information of people, especially people who, as argued by the I forget the name, the petitioners, the Nubian people, that they could suffer discrimination if this if the plans of the government go on in terms of the Huduma number collection, if they go on the way they do. We don't have enough protection of people's data. And so the court was saying this bill is in progress, it needs to pass and all that. And so from what I was saying is that if the government, just as you said, really wanted the Huduma bill to pass, and if this act gives way to other acts or other law, or even just court orders to come and supersede, then really the protection that the petitioners were seeking and the protection that the court was trying to give does not, in essence, is not really protection in any way, because another act can just come and then this act can supersede whatever protection, quote unquote, the act was providing. So that was going to be my last.
Okay, thank you, Enrique. So basically what we are seeming to conclude is that the Data Protection Act is not worth the paper it's written on, and that really our information is up for grabs, both within our jurisdiction and outside of it. Right, thank you. Chelsea? You have something to add?
Yes. I don't know if it's an addition or however it can be phrased. But when you've mentioned the Data Protection Act, it took me back to a time where I think Kenyans were really complaining of how, how much of their data is out there. And I think uh, people had, I don't know what kind of application was going on, but what I remember was it's sort of like the government was, oh yes, like when you're going to, there's this time when Safaricom was threatening people that they're going to switch off your lines if you don't go and register or something of the sort. And some people were like, but I have registered, why am I still being called to, sort of re-register? And the moment you go and I think re-register, you're sort of like, imputing your information from the word go. So it makes someone wonder, is it really true that my data was out there, or is it that you want to now collect the data from me? And then I think also there's something about the Data Protection Act on the issue of how, most kinds of data about Kenyan citizens, like you cannot move it outside the country without, their permission. But then sometimes you get to hear about news, maybe about Kenyan citizens, like maybe people from outside are able to have access to it. So for me now, that raises a query. I think just as you have said, and as maybe Arike was trying to say, if I got her clearly, is that the Data Protection Act it seems to be just a piece of paper, because so much of our information is out there, and many a times you have not even consented to that information going out there. So then now you begin to ask yourself which forum or which platform or which channel was used to be able to obtain this information from you, to the extent where sometimes there are pictures that maybe you posted on Instagram, for example, but you end up finding those pictures on Google. And as far as I'm concerned, Google and Instagram aren't really the same thing, and they're different platforms, even though they might be owned by people who know each other or more or less the same person. I don't quite get how your information is posted on one platform and then you end up finding it on another platform where you did not even consent to it being there.
Yes, that is actually a really good point, and that's partly to do with the weak laws that we have surrounding data protection and sharing of information between government, between different institutions and organizations. For example, the example you raised about Safaricom and what they were telling people to register was actually a really good example of how, if left to their own devices, really we as the consumer could really be bullied into signing away our lives, quite literally, because what I suspect was the key aim at making people who have already registered re-register again was to re-register under new terms and conditions, which would allow Safaricom to use your information with even less protections than you did when you initially registered. So that now they want to take advantage of maybe the loopholes in the new legislation, and so they try to force you to re-register. And then what you're not realizing is, because none of us ever read those fine prints, those term and condition, the button that you're told to press and read the terms and conditions, then you click that you've read and understood. I bet you, and I'll be honest, I barely go through that, because I think, number one, I don't have time. Number two, it's very long and made purposely long with very difficult to understand language and in very literally small print that you're not going to spend time. You click I've read and understood and you go in and you've registered. But what you don't realize is what you've registered for. And if you read the fine print, you'll find out they can use your photographs, your images, your text messages, all sorts of things. So it becomes a very, how do you call it? A very not aggressive, a very authoritarian kind of way of dealing with customers, and that is within the private institutions, just Safaricom, etc., which kind of have a monopoly, if you quote unquote monopoly. But now, if you give government that type of power and free reign, then you end up finding yourself in a very sticky situation where nothing that you have is actually safe. Nothing that you put online or nothing that you put down on paper is actually safe. Yes, go ahead, Arike. You were saying something.
Yes, sorry. Maybe could I just go before Arike? You've mentioned something, and it's brought me back to our class. there are times where I think everyone in Kenya must have gone through this, where someone calls you from maybe community prison, or someone
Yeah.
calls you from whichever part of the country, and they are
Yes.
con people. And this is someone that you have never spoken to. This is someone that you have no relation to. And then you constantly keep on asking yourself, where did they get my data from?
My
Where did they
number
get
from.
my phone number from? And some even call you, exactly. And some even call you with, you know, they are like, they call you and they know your name and things like that. So it took me back to the GINA Act, where there was the provision that spoke about the enforcement of an authority. And I was just asking myself if there's a way that, you know, the data protection industry can sort of borrow that from the GINA, whereby they sort of put in someone in place. I know there is an office, but then I don't think that office is as effective if people from committee can still get access to me without me getting access to them. So I'm looking at a scenario where there is an authority in place, an effective, suitable authority in place that mitigates such things and ensures that people's information aren't out there. Because sometimes this information is not even used for the right thing. Maybe one time you called and you're told that you took a loan from maybe Tala or whichever kind of this funny loaning schemes, and you've never even heard of them. So it really raises the query of how our data seems to be out there without our knowledge.
No, absolutely, and that's the problem. The fact that someone from committee is calling you means that someone has either given away or sold your information to someone so they can misuse it to commit acts of to commit criminal acts. That's number one. And the people have done that in the full knowledge that there's no legislative framework or even technical framework to prevent them from doing so, which means that there are not going to be any legal consequences for their acts. And this is now the problem with companies that handle information, or data controllers, as the Act defines them, is that really at the moment they don't really have any real framework within which to operate and any real consequences for mishandling of data. So now, now imagine what would happen. That is only dealing with phone numbers and ID numbers. Now imagine what happens when it comes to genetic information. To be a free-for-all, pretty much. It will be a mess. You know, case in point, I found out recently that someone used my ID details to register a phone with that Safaricom, which supposedly has my ID details, and there should have been a system by which I should have been alerted that someone is using the ID to register another number. Are you aware of this? Blah, blah, blah. But there isn't. And so it was used, and unfortunately, I had to deal with the consequences of that. So again, misuse of information, combined with the fact that there's no robust, proper regulation in place or legislation in place, means that it is basically a free-for-all world. And really, nowadays, information is God, is king nowadays. It's not water, it's not gold, it's not titanium. It's actually information. Information is what is worth, you know, something these days. So it's hence the need to actually have proper frameworks and systems in place to protect that information. Okay, finally, Arike, before we move on.
Okay, thank you. So the last, I could say a lot about this act, but the last thing that I want to talk about this act are two things: section 52 and section 54. Particularly section 54, where the data commissioner may prescribe other instances where compliance with certain provisions of this act may be exempted. Really, like I have tried to understand that section of the act, and I still cannot understand why an act that is meant to protect such an important thing for Kenyans is giving an officer the right to say certain provisions of the act do not necessarily have to be complied with. And since you have knowledge of the act, maybe you can tell me why that part of the act exists at all, actually, and any circumstances why that could even be put there. And then section 52, the principles of processing data shall not apply where the data controller reasonably believes that the publication will be in the public interest. The data controller reasonably believes that in all special circumstances, compliance with provision is incompatible with the special purposes. Again, this idea where the data controller is given the leeway to reasonably believe something, and then you are free to publicize, to publish the um, the personal data of a person, which personal data has been made to include genetic information, really blows my mind, because we are talking about literature. Literature could include, like, medical publications are considered medical literature, and so if you reasonably believe that the public needs to know something like this research, where we are talking about that a number of in America, they are saying that African Americans are more susceptible to sickle cell. So if you reasonably believe that Kikuyu people are more susceptible to, I don't know, something you got from their genetic information, then you can publish the genetic information, and your defense, which is good in law in this act, is that you reasonably believe that you, as the data processor, that again, this small threshold of reasonable belief that we put there is really also something that I cannot reconcile with, given the decisions I have read from our courts, where the interpretation of reasonable belief was what the courts were deciding. So I would like to know these two particular things, why they are even in the act that is meant to protect information of people. And as you've mentioned right now, information is such an important thing, and it's so easy to access. And you would think that the government would try and make it just a little bit harder for people to access the information of its people.
Yes, I think the simple, straightforward answer to that is I'm just as flabbergasted as you are that those provisions exist, because for me it is like, now an act that's supposed to give basic protections is basically saying that now the decision making is left in the hands of one officer who is susceptible to influence either from government or private entities, because then they can decide from one day to the next. And also what they don't do is give criteria for that officer to exercise their discretion, as it were, because that's basically what they're saying, that the officers have the discretion to decide when certain provisions apply, when certain provisions don't apply. So basically, it's just co-opting that officer to basically act according to the whims of government primarily, and possibly other actors, whether state or private or whatever. So for me, that is a problematic scenario. Look at the Weber's situation where something similar happened, and basically all Weber cases now, instead of them going to court, now are going to the director general for Weber for them to determine. And because of that, it means people might not get fair trials. The director for Weber might act in concert with the Employers Association, in concert with government actors, etc., private sector, to basically make sure that all these Weber claims are either thrown out, or they're delayed, or they're dealt with in a manner that basically ensures that the claimants do not get any justice, or do not get any compensation for their work injuries that they've sustained during work. So another situation where, a bill that was an act that was passed way too quickly, but obviously it was passed quickly because the court and all the commentators at large were saying you cannot have a Huduma Act when we do not have an act that protects such information as is being collected by the Huduma bill, or what is being proposed to be collected by the Huduma bill. So these are very important questions that you've raised, and actually points of critique as well. So that even as we're moving forward, because some of you might end up as researchers in Parliament. It happens a lot. Even today, I've been told to look for students who are interested in doing research jobs in Nairobi, but obviously they want people who have graduated. So there is a desire for researchers. So with that knowledge, you can actually advise your employers that, okay, these are the loopholes, this is the critique, and this is that, and this is maybe what needs to be changed. But so far, I haven't seen any amendment bill in the works for the Data Protection Act. So we're yet to see what will happen, what will be the consequence of this. Right, so let me move on because I see we don't have much time. I want to reach us to a place where we can pick up from easily next week. So I'm going to now switch to the biobanks, okay? And I'll just give a brief introduction. Who was going to present on the banks? I'd given that to someone on the Iceland. I'd given 2 people, actually, if memory serves.
Ibrahim, was to present. Yes.
Okay. How long will your presentation be? So I know whether we finish with you or we start with you next Thursday.
Malimu, if you will ask me to just highlight the courts, because you told me to just check the case from the court of the first instance up to the Supreme Court, and I realized there were only 2 courts. If I have to summarize, then I can summarize. Otherwise, because there are other issues that I also wanted to highlight, especially when the Supreme Court was making the determination, the number of issues there it was also considering. So if I have to go through them, then maybe next week will be great. Otherwise, if I want to highlight, I can highlight. I think it will not take me a lot of time just to.
Okay, then let me do this. Because if you've got something detailed, let me give a brief introduction, and then who was going to present on Greenberg versus Miami Children's Hospital, and then Regents versus Moore University. So Fatma, you're going to do Greenberg, right?
Yeah, I'm going to do Greenberg.
And then who was going to do Moore versus Regents University? Wanjiru Chelsea. Okay, sawa. So let's do this. Let me just do a brief. I want to do a brief. Okay, actually, let me do this. I was going to finish with this next week, but I'm going to bring it up to cover the next 10-15 minutes so we close. I'll do the introduction to the biobanks next week before Ibrahim presents. So one thing I wanted to just quickly discuss is, hold on, just bear with me a second. Yeah, I just want to talk about consent very quickly. Because that's one of the issues that we've raised that comes up when it comes to genetic information and how that information is used and or abused or misused. So consent is another issue that is raised. And these are questions I want us to think of as we do our reading on genetic information, whether in the context of the Icelandic biobanks or the Greenbergs or the Moore versus Regents, etc. Is the issue of consent, because consent crops up in all those 3 scenarios that we are going to go over next week. And actually, it's probably better. It's actually a good idea that those 3 case studies are dealt with in the same session, because they'll deal with issues of consent amongst other things. So consent issues, okay, in the context of genetic information. Can an individual consent to the collection, use, and disclosure of genetic information that has implications for extended family members? Okay. These are questions to consider. So please, make a note of them, because these are questions that you'll be asked to analyze and investigate, whether in the CAT or in the exam. Remember, I'm telling you about CAT and exam because they're impending. I think a draft timetable has just come out, and LST has been put to be on the 31st of May. But that is still not yet finalized, but just to let you know. So if me, Ibrahim, and Arike are family members, okay? Let's say we're in a nuclear family. Arike is my sister and Ibrahim is my dad. And Ibrahim goes for a genetic information test. So has Ibrahim consent, because of the nature of the information that will come out from that test, have Arike and I consented to our information being used, even though it is Ibrahim who went to do the test? because the eventual consequence would be, or implication would be, that from Ibrahim's genetic test, they can find out about Arike and me, our genetic predispositions, our genetic weaknesses, our genetic strengths. They can find out about our ethnicity, and so on and so forth. And then another question becomes, since genomics projects such as the Icelandic one are longitudinal and open-ended, the risks cannot be identified in advance. So can you give future consent for any action with your genetic information? And can said future consent be said to be informed consent? Because we have, I don't know if you've dealt with consent in any other unit, any other module. Maybe consent would come in, maybe in criminal law, consent can come in there. Which other area of law would consent be an issue? Human rights?
Evidence law.
Evidence, thank you, evidence law. So we have consent, the way we understand it in the layman's terms. Then we have informed consent, which comes into play in LST, whereby, is it that I've consented to you to put the injection in my hand and remove blood, or which is consent? Informed consent would be what I'm using your blood for, and the potential risks attached to it, the potential benefits. Now that would be informed consent. So now the question is here, since genomics projects like biobanks and certain research, especially when you're researching a certain group of people, a certain ethnicity, a certain race, whatever, and they're very open-ended. The information that stays there does not just remain viable and end with that one purpose. It can actually be used for a variety of purposes. So can you give consent for your blood to be used in the future? Maybe they've used your blood for the test, to test for, I don't know, sickle cell and your tissues. Then it's kept in a freezer, in a nitrogen, freezer. And then 10 years later, they're like, oh yeah, let's go. We have these samples here that we're using to test for sickle cell. Let us try and test for this other sickle cell related illnesses. Did you give consent for that, for future use of your tissue? And even if you did, was it informed? They inform you of the possible risks and how those risks would be mitigated by the person taking your information, your genetic information. Also, there's now become a discussion about, because consent is not just the usual just yes, that we know and understand, and especially in the context of genetic information, now consent is starting to branch out into all these subsets. So is the consent one-time consent? Is it a two-time consent? Is it a future consent? Is there presumed consent? Because is that ought to know versus what you know and what you ought to have known? So should it have been reasonable in my mind to presume that my blood would be used for this other testing that I may not have originally consented to? Would it be presumed that I've given consent for them to test not only for presence of antibodies in my blood, but also my blood group? You see, also, is there an opt-out consent, that I'm allowed to opt out of these other extraneous things to what I've actually come to get testing for? And then what is the proper model of actually structuring or conceptualizing consent? What is the correct model that we make sure that you and I, as the weaker party, because we're looking at us versus the biobanks and government, which green lights these biobanks and pharmaceutical companies and research facilities and all that. What is the proper structure by which we achieve a proper balance where we are not infringed upon, and then also understanding the importance of research and medication and drugs and vaccines, that we also do not slow down progress, because there's this balancing act that needs to be played. We all agree that it's important for researchers to do their work, although we don't really want to know the details of that until it affects us. But now when it affects us, should we be afforded certain protections to make sure that our genetic material, our genetic tissue is not being misused? Okay, so there's this implied consent, express consent, informed consent, future consent, opt-out consent, a blanket or open consent. So there are all these kinds of consents that now have started to become a main feature rather than just, you know, abstract concepts before, because of the subject matter that is in question. Also, now when it comes to protection of genetic information and kind of towards the idea of privacy, there's this movement that is kind of trying to push forward the idea that genetic data can be anonymized. It can be, what is the regular, what do you say in WhatsApp when your information can be encrypted? I think the word is encrypted. So they're proposing a similar function for genetic data, so that now it cannot be identified easily, even though it is kept on a computer or stored in a cloud. So where there is no reasonable possibility of identifying a specific individual, either directly or indirectly, through manipulation or linkage of information, there is no need to provide privacy protection. And this is a position that was brought out under the Health Insurance Portability and Accountability Act, and I believe that is a Canadian statute, either Canadian or American. I will confirm that for you. And then what the identifying information has been defined as under this act is that it is information that identifies an individual or for which it is reasonably foreseeable that it could be utilized either alone or together with other information to identify an individual. And only identifying information is included in the definition of personal health information under this act. So now the question becomes, is that definition enough? Should it be more detailed? Because what are we thinking of as identifying information? Is it an ID number? Because it could be anything from your ID number or name to your genetic DNA makeup. That's how wide it is. So now when you're looking under health insurance, because all that information is relevant, your name, your ID, and your DNA sequencing or genetic makeup. So is that enough, that definition of identifying information enough, or does it need to be more robust? Does it need to be more stringent or strict or specific, or should it be that wide so as to cover as many constructions of identifying information as possible? These are also other considerations that need to be thought about when thinking about the making genetic information private, because this is being seen as a mitigation of the potential harms that could happen when genetic information is collected with or without consent. The people are saying, oh, okay, fine, yeah, consent this, consent that, but what if we are able to anonymize or encrypt genetic information? Would that then make you quiet now? Would that make you feel, okay, fine, it's okay because my genetic information, even though I've not given consent for it to be used in this way, but at least it's being encrypted, at least it's being anonymized, so no one can find out who I am and therefore find out who my immediate family is, or find out who my clan is, who my tribe is, who my race is, etc., etc. So that's, those are kind of two opposing arguments that are being given. But then now the people who are saying, okay, let a solution would be to anonymize genetic information. Now the people who are against that are saying, actually, if it can be anonymized, that means it can also be de-anonymized, can also be de-encrypted. What does that mean? The same methods that you're using, or the same programs or data or systems that you're using to encrypt this information or anonymize this information could actually be stolen, or they could be, I mean, we have hackers for computers who hack into governments, databases and all sorts. So the same thing could happen with genetic information if someone wanted it badly enough. And some people argue that genetic information can never be de-identified. And a few dozen gene markers may provide enough data to uniquely identify an individual. And we have this doctor called Dr. Khaled El-Imam, who has described methods that may be used to ensure that the risk of re-identification is very low, but also acknowledges that improved methods for the identification of genome sequences or genomic data are needed. So now he also says, even if parts of a DNA sequence are suppressed, i.e. hidden through these anonymization programs or systems, a skilled geneticist can most likely reconstruct the missing sequences based on information that's already available out there about certain groups of people, certain ethnicities, certain families, certain genetic makeup, certain races. So now the question becomes then, is our information really private? Is it really safe, regardless of all sorts of frameworks that might be put into place? Is it really safe? So then what becomes the best way to collect this information and to keep it safe from misuse? Okay, and so we have this policy, United States policy, that was released from the U.S. Congress, House of Representatives, the Committee on Government Operations in 1992, and they stated that the routine availability of, and this is as far back as 92. Okay, just note that 92 is about what, 30 years ago, 31 years ago, and it says that routine availability of identifiable genetic information about individuals may have effects that reach far beyond the provision of medical care. As the amount of detailed genetic information grows, society may be required to re-examine the basic principles of health and life insurance, review the rules that govern employment and hiring, reconsider the confidentiality rules that are part of the doctor-patient relationship, and in general, reassess the way in which individuals are categorized and treated in a variety of social and economic relationships. So just let me pause there. Think about this. This Committee on Government Operations statement was made 31 years ago. In 2008, the GINA Act comes into play as presumably as a result of this parliamentary statement or Congress statement that has been made in the United States. I want us to think about whether something similar has even been acknowledged in our Kenyan parliament, whether the lower house or the Senate. Whether the National Assembly or the Senate. Lower house and upper house is American language. Whether in National Assembly or the Senate, that has actually informed the creation of these bills that we're looking at, whether it's Huduma, whether it's data protection, and a myriad of others, especially when it considers, where there are acts that consider or that deal with healthcare and the health professionals' interaction with the patients. And I'll venture to say they're none as holistic as this statement, because this statement has acknowledged the identifiable nature of genetic information. It has acknowledged the amount of detailed genetic information, the increase of it. It has recognized that the basic principles of health and life insurance need to change, that employment and hiring needs to change, that confidentiality rules need to change, that the doctor-patient relationship needs to change, consent, and the categorization of people, and which leads to discrimination and all that kind of thing. So it goes to show that certain jurisdictions were looking ahead whether for altruistic reasons or personal reasons, self-interest reasons, because I'm sure there are many parliamentarians who are very aware that the information could be, used by the FBI or the CIA and so forth. So there must be a level of personal interest in making this statement for sure. But then the means justifying the ends, if that is something that is appropriate in this discussion, is that it was recognized as far back as 1992 and has led to what could be seen by the United States citizens as positive moves towards avoiding discrimination against them, whether by government, by insurance companies, by employers, and so on and so forth. So the conclusions I was going to suggest or make is that genetic information raises serious privacy and human rights issues, not only for individuals, but their families as well. In Canada, genetic information is currently protected by provincial, federal, territorial privacy and human rights statutes, but not as well as in the United States and other jurisdictions. Okay, and case in point being the policy statement by the Insurers Association as it pertains to genetic information. Because yes, as we've acknowledged earlier in this class, yes, there are human rights legislations that can do a good job, but considering the special status of genetic information, there needs to be something more robust. And then other conclusions that can be made are the US, EU, and UK have gone much further than Canada in introducing legislation to prevent genetic information from being used to discriminate in employment and insurance contexts. And this begs the question whether genetic information requires further protection in Canada. I believe it does. Also, if you bring it back home to Kenya, we definitely need, I don't even think the question is about further protection in Kenya. It's about basic protection in Kenya that is actually meaningful, that actually, especially considering the changes that we have gone through in the last 4 to 5 years as pertains data and as pertains genetic information in particular, which will start becoming a big thing as government starts to see its potential use in whatever sector, in whatever field. I'm not trying to say government is bad. Of course, that is a sweeping statement, but potential misuse is something that should always be at the top of our minds when it comes to genetic information and its protection. And then the question becomes, how do we protect? And is protection done after the things have gone wrong? Do we preempt? Do we protect, or do we cure? And if we're protecting, how do we protect? And if we're curing, how do we cure in a way that does not make things worse, that does not require a preemption of the bad event or the misuse of genetic information happening? So that was going to be my conclusion. But now what we've left for next week is a discussion about the Icelandic biobanks, and then the Greenberg case and the Moore versus Regent case, which actually I think works out better, because that means we are all on the same boat. We are all going to read on those 3 cases, and we're all going to come back, and we're all going to discuss these the issues that are pertaining to these cases, and not just leave it to 2 or 3 people in the class to discuss. And when I say that, I'm talking to you. I won't mention names. You already know who you are. So let me leave that with you. I see Ibrahim's hand is up. Ibrahim, go ahead.
Yes, Malim. I think that you posed a very interesting question with respect to consent in a family setup. For instance, I'm a dad, and then I consented. My data was taken and stored in a data bank, or gene bank. My children may come and say, okay, one of them said, now I want to use data because it's affecting me, to be removed. Another one said, no, it should not be removed. It should be there. And then even the grandchildren can come and say, now we want the data of our grandfather to be removed because it's affecting us. So I think this becomes very complicated and actually can lead to family breakup if everybody now wants to assert his right of consent because this one affects his right or privacy and such things. So it's a bit problematic, and I think we wanted to have your maybe views because you posed a question, but yeah, or even the class can contribute on their views with respect because this can actually lead to breakup of families.
No, of course, that's a potential, but a very huge potential for that, and also it would create it would also create a weird legal position where you have different family members, some of who are saying remove my father's DNA from your data bank, and some saying no, keep it there because we might need it for for a cure later on. We might need it to find our ancestry or whatever reason that comes out. So that whose needs and wants would prevail in that sense, and then whose consent or whose lack of consent would prevail in that situation. So that's a very interesting question, and that's why I posed it, so we can all think about it as we're doing our reading and then come up with suggestions, because I don't think I have an answer to that per se. All I can say is that is the situation that we will be looking at next week with the Icelandic Biobank, because the person who started that case was a daughter of a father who's had died, but his genetic information had been kept in this biobank in Iceland called something gene or some, I can't remember what its name now is. It's gone out of my head. But that's not important. The important thing is that now what the Icelandic decision is certainly suggesting is that a family member can come and challenge another family member's consent for the use of the genetic information on the grounds that that information is also identifying of me. It identifies me as well. Okay. So if let's talk about sci-fi situations. If there's a if biological warfare is going on and a biological agent is released that was based on, to use that example of myself, Arike, as siblings and Ibrahim as our father, who has deposited his genetic tissue material at a biobank. If we're in times of war and they decide we're not going to use guns, we'll use biological warfare, and they take Ibrahim's DNA to create a poison specific for him and the people of his group, of his ethnic group or whatever, that means me and Arike are dead because we share the same DNA. And actually biological warfare is not, it was used in World War II and World War I to devastating effect. And you could actually isolate groups of people to attack with biological warfare, as opposed to guns, which you just shoot and it kills whoever is in its way. But biological warfare is more sneaky and direct and to the point, and you only need a few genetic markers to make that biological agent attack the people who you want to attack and leave the people who you don't want to attack. And for example, we've talked earlier about how one of the advantages of using genetic testing and genetic information and all that is that you can actually personalize medicine, because everyone's genetic predispositions are different, and maybe what is out there might be fine for a majority of the population, but you might be in the minority who that drug does not work for. And so when they find out your genetic makeup and structure, they can actually take that drug and tailor make it to suit you and to be effective for you. So if they can make a drug that works specifically for you to your benefit, what is to stop someone making a drug that would specifically target you through your DNA and genetic makeup? Nothing. Anything is possible. The only thing that's stopping that from happening is, morality and, goodwill towards man, fellow man, and not wanting to harm God's creations, whatever it is that you might insert there to be the barrier. But if it's possible, it's possible. The only question is what would it take for someone to actually go ahead and do it? So yeah, that's what I could contribute for now, but I'd like to leave that greater discussion for after we've discussed this biobank case study. So please repeat it again, write it down, the question you asked, Ibrahim, and repeat it again next week. So hopefully we can get more contributions, because everyone will be reading those 3 cases. Arike, go ahead.
Mine was just on the mention that we made of the fact that we need an actual law to protect our genetic information, because what we have right now is a joke. I was thinking that the issue, and it's a problem I have a lot with the legislature in every government that comes and goes, is that we are very reactionary. If you bring it up right now, it will be that's an issue in Kenya at the moment, until there's an actual problem, and now they start panic making laws, and then you have the kind of laws that they come up with that you look at and you feel very embarrassed to say that we have a parliament. And so I don't think we are going to get, you even mentioned there's no bill waiting. I don't think we are going to get anything better than what the purportedly data protection bill that we have at the moment, because it's not, I don't think it's anything that anyone in parliament is thinking about right now in terms of, people every day are getting their blood drawn. There's this, is it called 23andMe or something, where you can check your ancestry. And like, Kenyans are not big on it, but someone could be online and could be interested, and it's worldwide. And you just put your data. No one is thinking that there's genetic information of Kenyans running around on the, like, in this World Wide Web thing that we actually need to protect. So I don't think we are going to get any better laws anytime soon, until there's an actual problem, and then we are going to panic create a law that's not going to serve anyone in any beneficial way.
Yeah, I do agree with you on that point, on the fact that our laws tend to be reactionary for the most part. I mean, of course, there are certain laws that can't help but be a reaction to a certain event that could not have been preconceived, or even imagined. For case in point being the recent pandemic, which I guess we're still in, although we're not in the critical part of it. But certain laws had to come in because that was a very unprecedented scenario. But then the problem becomes when all or majority of your laws tend to be reactionary and not looking forward. And that's what I suspect will happen with the Data Protection Act, is that it will only be amended when something big happens that puts all of our information at risk. And that's when you'll start seeing amendments. But at the moment, I don't think that's a priority for parliamentarians. People are busy trying to push other agendas forward, which is fine. But as we were talking about in the beginning, you know, a really good law really should look not just at the present circumstances, but also should be looking into the future, so that we're not wasting time amending it or reading it or doing all of the kinds of stuff. A marker of a good law is one that stands the test of time, to be honest, not one that's constantly being changed and being looked into to be amended, because we found out 5 years from now that this law is now no longer relevant, because when it was being drafted, it was not looking forward. It was only trying to put out a certain specific fire in that certain specific time. So yeah, unfortunately, I don't see that happening. I think the next energies will be on the Huduma bill, and maybe that's when people will start making noise about the inefficiency of the Data Protection Act. Maybe not, but chances are people will not. It will go through, and then, as with the Data Protection Bill, when people start realizing that they cannot take their kids to school because of the Huduma number, they cannot get access to hospital healthcare because of Huduma number, that's when it will start hitting the fan, and then that fire will need to be put out. So yeah, because to be honest, I've not heard anything about the Huduma bill being, or people really coming out to show an understanding about the Huduma bill and how it will actually affect the day-to-day life. But yeah, watch this space. We're yet to see and understand and see whether anything will of note to really happen to kind of make us have proper laws that protect not only our general information but also our genetic information. Because ultimately, the Data Protection Act should have been looking beyond telephone numbers and ID numbers and KRA pins. It should have been looking at genetic information. Ideally, that's what it should have been looking at. But for me to have to sit there and know that my my genetic information could, or my rights under the Data Protection Act could be blocked by a certain officer because they deem that certain provisions of the DPA do not apply, that sends chills down my spine. Because by the time I've gone to court and sued the data controller under the act, my information is gone. It's in a cloud somewhere. And even if I get damages, even if I get a judgment in my favor, it's too late. It has already been used or misused. So there you go. The law can be a pain sometimes, but it is the law. All right. So on that, okay, yeah, go ahead, Ibrahim.
Mwalimu, with respect to this data processors, data
processors, yeah, data processors and controllers, etc. Yeah.
And data controllers. I've realized there are a number of data controllers who are not even registered as required by the Act, and even compliance, enforcement is not happening. And you see, these people are collecting a lot of information, but they're not even, the law says they should be registered as a data controller and a data processor, but they are not even registered, and they are collecting information, they are handling, and then there is no enforcement also. I don't know whether because of manpower issue, but I realize it's not even enforced as such. But I was looking at the Act, their website, and there are almost 1,000 companies which are registered as data processors and data controllers, but there are a vast number of others who are not registered, and they are required to be registered, and they are continue collecting personal information, and we're getting putting us to risk of exposures. Yeah.
No, I agree. I think it's just to be quite honest, Ibrahim, like how do I say this? This is a personal opinion. This does not reflect the opinions of the University of Nairobi. Let me put a disclaimer out there. A lot of times laws come into place. They put the cart before the horse. And really the driving force is a certain agenda or a certain thing that needs to be done. And so a law comes into place without the actual structure or framework being there to make sure that that law actually works and is effective and actually is carried out properly, is monitored properly, is enforced properly. Case in point, again, I hate to harp on it, but it's the truth. The Huduma Bill, which exists. And so now we have people's information that has been collected in the name of getting a Huduma card or Huduma number when the Huduma bill is still a bill and is not an act. Okay? Putting the cart before the horse. That information that has been collected was collected, but without having a processing center or a data storage center within the jurisdiction of Kenya. That so much so that after the whole exercise, now MPs started complaining in Parliament. I think that was in 2020, I think, or 2019, started complaining that they've just found out, quote unquote, just found out, when really they should have known before or did know before, but because it did not affect them personally, they were not going to say anything about it, just found out that all that information they collected from all of us during that exercise is sitting in a server in France. Then that information started coming out. But then Kenyans are like, bora uhai and all that stuff. It's like, whatever, they've taken my ID and my KRA pin, let them do what they want. Me, I need to find food for my kids. So now we have information out there that God knows what it's being used for. And by the time we find out it has been misused, case like what we were talking about privacy issues, it's too late. It's gone. It's been bought and sold 10 times over. And it's being used to profile you, to target advertising for you, to target marketing campaigns for you, and God forbid if they had gone ahead as they intended to take our blood samples as part of that exercise, then they would be testing on our blood to find out all sorts of things and be planning all sorts of things against us. That's just my point of view. But that they've put the cart before the horse, not just in this bill, in many other instances, in many other sectors of the law or of the economy, they've put the cart before the horse without actually having confirmed that we actually have the structures in place to make sure that this law, this act will actually work. Because if you don't have the structures in place, the manpower in place, the structures, the institutions in place, the funding in place to pay these people, then that act is nothing more than a piece of paper that might as well be sitting in a toilet. That's just my view. But then it happens so often that we've become so, immune to it. We don't feel that that's a big thing anymore, but we really should. We'll only feel it's a big thing when we find out our DNA is being bought and sold on the black market. So, yeah, that's where we are right now. But that's where you come in to change the world. Right. So on that note, it's 29 minutes past 5. Thank you for staying with us, staying the course. Next week will be our last session. I will endeavor to disseminate the CAT before our session next week. I'm having a training on Mtihani tomorrow. So once I figure out how that works, and hopefully that all of you are on it, I will probably administer it during the weekend. And I'll have a plan B just in case, as I've heard from other members of the class that they're having difficulties in other modules. Right. Chelsea, yes, go ahead.
Just a clarification question regarding the CAT. You had assigned us groups some time back.
Yes.
So just confirming that it's still a group work related CAT.
No, it's a group work related CAT. I will assign a certain amount of marks for the written and certain amount of marks for the presentation. Everyone has to present, everyone has to talk in the presentation. It has to be a proper group work presentation, because I don't want this thing of you pick one person to talk and then everyone else sits quiet. That doesn't work for me, because we're trying to also develop other skills, not just your writing skills and your research skills, also your presentation skills. In real life, before this this post-COVID world, we would set a day where everyone comes in and you're judged on your appearance. People used to turn up professionally dressed, and they have, mapped out how they're going to present it within a certain time, and questions were being posed, which we'll also do on this online platform. And you also marked on how you answer, how you think on your feet, and how you deal with questions and how you answer them. So that was all part of the assessment, because we don't want you going out there in front of Justice so-and-so and so-and-so and embarrassing us. And then you say, oh, Mr. Sige taught us. No, I don't want that. I'll deny you like Judas.
Okay, thank you.
Yes, any other question? Thank you for that question. Any other question? Any question, thoughts, comments? Right, okay. Just for you to know, the exam is being drafted. It will probably be handed in for moderation next week. So please be on your toes, be practicing, be reading, be interrogating, be asking questions. Look at the past papers as well, so you understand how exam questions are asked and you prepare yourself accordingly. Don't go into the exam room being the first time you've seen an exam question on LST. Make sure you are going through past papers. Right. So if there are no more questions, thank you very much for your attention. Next week, we're finishing this topic and the syllabus in total. And I expect there to be a full house, kindly, because what we're discussing next week will definitely show up in your exam. I can't tell you how it will, but it will definitely show up. So if you're there to ask questions and understand and contribute, good for you. If you're not, too bad. You just have to deal with the consequences, I suppose. Anyway, have a great weekend. Water your plants, put on your masks, social distance wherever you can, eat healthy, get some sleep. Have a good weekend. Goodbye.
Goodbye. Thank you.
Thank you.